Okay, so we're recording this now. So first things first, you start with the seller. On the MLS, it's found at the bottom of the listing, owner name under listing information. I also like to click on the link, verify public record. So this opens it up into Realist, but I also like to launch LIPA. So I click on the link, go ahead, hit enter, pull up the parcel details. And here we are. And we see that we have Werner H. Hank is the owner. Okay. And then buyer, we've got Mr. or we've got Jane Doe and John Doe. Okay. Address. I'm big on copy and paste. Okay. Legal description. Found right here in the MLS. Again, we're going to copy and paste. And then within public record, it's found right there. Section, township, and range. Okay. This is actually the first 3 digits within the PID. Okay. So 17, 44, and 24. It's also found right here in the listing information in the MLS. So 17, 44, and 24 we're going to enter. 17, 24, 44. Okay, see, first 44 and 24. I think I goofed. Okay. So 17, 44, and 24. And you can see that it's there as well. Okay. We all know that Cape Coral is part of Lee County. And property ID is the entire strap number. Okay. You can see it's right here in the MLS. Okay, including all improvements existing on the property and following additional property. So if there's anything that's being purchased with the vacant land, you may include that here. This was on a case-by-case basis. I'd say, more than 90% of the time, you're probably not going to include anything there. Okay, purchase price of the property. This one's listed at 42. Let's say we're gonna offer $40,000 there. Okay, escrow agent name. You can see here, Lee County, it's typical for seller to pick and pay for title, and this listing agent specified who the seller is opting to choose. So we're gonna go ahead and just agree with that. Okay, Coral title. We don't have a contact person, but here's their address. A phone number. An email. Initial deposit, it's 0 if left blank. Okay, you can have it accompany the offer or will be provided within 3 days, and by default, if you leave that blank, it will be 3. Maybe we're doing a $2,000 deposit on this $40,000 purchase. Okay, additional deposit to be delivered to escrow agent, if applicable. Maybe we'll do a feasibility study, and on day 11, we'll enter an additional deposit, maybe another $3,000. Total financing, there won't be financing involved in this. It's rather difficult to obtain financing. I'm not going to say it's impossible, but it is a little more difficult to obtain financing on vacant land rather than an existing structure such as a single family home or a condo. Other not applicable. Balance to close. Okay, so 40,000 minus 2,000 minus 3,000 leaves us with $35,000 left to close. And then this one, line 32, complete only if purchase price will be determined based on a per unit cost instead of a fixed price. The unit used to determine the purchase price is lot, acre, square footage, or other, and if other specify, prorating areas of less than a full unit. The purchase price will be blank per unit based on a calculation of total area of the property as certified to seller and buyer by a Florida licensed surveyor in accordance with paragraph 8C. The following rights of way and other areas will be excluded from the calculation. Okay, so typically, more than likely, this will be used when developing an entire community or a large development similar to that, where you will have multiple lots and you will have to determine the calculation of the total area and what's specified here. Probably not going to use that much at all. Okay, time for acceptance, effective date. Unless this offer is signed by seller and buyer and an executed copy delivered to all parties on or before blank, I typically like to give 24 hours. So in this case, I would say on or before I like to say 5 p.m. Eastern Standard Time. On 1/5/21. This offer will be withdrawn and buyer's deposit, if any, returned. The time of acceptance of any counteroffer will be 3 days after the date the counteroffer is delivered. The effective date of this contract is the date of which the last one of the seller and buyer has signed or initialed and delivered this offer or the final counteroffer. Okay, let's stop right there. Does anybody have any questions about time for acceptance and effective date? This is very important. Okay. Moving on, closing date. This transaction will close on closing date. Cash buyer, and typically we can get this closed in 15 days. But because this person is doing the second deposit, maybe they need a little bit more. So we're going to go maybe about 30 to 45 days out. So today's January 4th. So we'll go with February 4th. Try not to, if there's financing involved, if you close at towards the end of the month, you almost buy the buyer one whole month before their first mortgage is due. If you close at the beginning of the month, then at the first of that following month will be their first mortgage payment. Okay, but again, because this is land and it's a $40,000 purchase, financing is probably not going to be involved. Any questions on any of that? Closing date or, okay. And number 5, extension of closing date. If paragraph 6B is checked and closing funds from buyer's lender are not available on closing date due to Consumer Financial Protection Bureau closing disclosure delivery documents, CFPB requirements, if applicable, then closing date shall be extended for such period necessary to satisfy CFPB requirements, provided period shall not exceed 10 days. Okay, but again, financing is probably not going to be involved with a vacant land purchase. Okay, so we're going to say that the buyer is going to pay cash, but let's walk through the financing part in case that there is financing involved. So this contract is contingent on buyer qualifying for and obtaining the commitment or approvals specified below, financing within blank days after the effective date. So if you leave it blank, by default, closing date or 30 days after effective date, whichever comes first, is what will be defaulted by leaving it blank. Financing period. Buyer will apply for financing within blank days after effective date. Leave it blank, by default, it's 5 days. I try not to leave anything blank on my contracts. And then when I'm reviewing my contracts, if you'll notice, there's asterisks here on the left-hand side next to the line item number. Anywhere that has an asterisk means that you, the agent, needs to do something on that line item. So, you know, I would put 30 days here. I put 5 days here, and that's if there was financing involved. But since there's not, I'm not going to bother to fill out anything here at all. Okay. If buyer, after using due diligence and good faith, cannot obtain the financing within the financing period, either party may terminate this contract and buyer's deposit will be returned. Okay. So if there is financing involved, what kind of financing will it be? Will it be new financing? Will it be seller financing? Will the buyer be assuming a mortgage? Okay, so let's take a minute to talk about what each of those entail. So new financing, buyer will secure a commitment for new third-party financing for you can either put a dollar amount or a percentage of the purchase price, and then you need to check one. Is it going to be a fixed rate, not to exceed blank percentage, or is it going to be an adjustable rate, not to exceed blank percentage? At origination, a fixed rate at the prevailing interest rate based on buyer's creditworthiness if neither choice is selected. Okay, so if you don't choose anything, by default, a fixed rate and whatever market rate is will be defaulted. Buyer will keep seller and broker fully informed for the loan application status and progress, and authorizes the lender or mortgage broker to disclose all information to seller and broker. Okay, so a seller does have the right to contact a buyer's lender or mortgage broker and inquire about the status of their application. And the mortgage broker or lender has authority to disclose such information. And here it is right here in the contract. Okay. The next financing vehicle would be seller financing. Buyer will execute a first or second purchase money note and mortgage to the seller in the amount of blank, bearing an annual interest rate at blank and payable as follows. So right here, you would disclose the terms. If this one line item is not enough to disclose the terms, you can say, you know, please see addendum such and such. The mortgage note and any security agreement will be in form acceptable to seller and will follow forms generally accepted in the county where the property is located, will provide for a late payment fee and acceleration at the mortgagee's option if buyer defaults. Will give buyer the right to prepay without any penalty, all or part of the principal at any time, with interest only to date of payment. Will be due on the conveyance of sale or sale. Will provide for release of contiguous parcels if applicable, and will require buyer to keep liability insurance on the property with seller as additional named insured. Buyer authorizes seller to obtain credit, employment, and other necessary information to determine creditworthiness for the financing. Seller will, within 10 days after the effective date, give buyer written notice of whether or not seller will make the loan. Okay, so seller has 10 days to perform their due diligence to determine whether or not they want to qualify the buyer for financing on their own account. Okay, mortgage assumption. Buyer will take title subject to and assume and pay existing first mortgage to blank with loan number in the approximate amount of blank currently payable at blank per month, including principal, interest, taxes and insurance, and having a fixed or other describe interest rate of blank, which will or will not escalate upon assumption. Any variance in the mortgage will be adjusted in the balance due at closing with no adjustment to the purchase price. Buyer will purchase seller's escrow account dollar for dollar. If the interest rate upon transfer exceeds blank percent or the assumption transfer fee exceeds blank dollars, either party may elect to pay the excess, failing which this contract will terminate and buyer's deposit will be returned. If lender disapproves buyer, this contract will terminate and buyer's deposit will be returned. Okay. Anytime you have a mortgage assumption, work very closely with your closing party, whether that be a title company or an attorney. Okay. This gets a little bit in the weeds, and really we want to leave this up to a professional that has much more experience than we do with working with something like this. So if there's a mortgage assumption involved, contact either the attorney or contact the title company and get their guidance on how this should properly be filled out. Okay. Number 7, assignability. Check 1. Buyer may assign and thereby be released from any further liability under this contract. If you're working with somebody that's a wholesaler, you may want to select this option. Okay. Or the following option, may assign but not be released from liability under this contract. Okay. So, okay, you want to wholesale it, great. You can assign the contract, but if that buyer defaults, you're still going to be liable and held on the line to close this contract. That would be the option that I would select. And probably regardless, I would always select that option. You can do what you want with this contract, but just know that I'm going to hold you liable, and we're going to bring this contract to closing. Or may not assign this contract, and don't even give them the ability to do anything with the contract other than what this contract specifies. Okay. Any questions on anything up to this point? Okay. Number 8, title. Seller has the legal capacity to and will convey marketable title to the property by statutory warranty deed, specialty warranty deed, or other. Again, work with title. Don't think that title's just there to close the property. I consider title one of my very good resources. I go to title quite often, even before I ever deliver a contract. Hey, title, what do I need to do here? What kind of a title? Is it going to be a statutory warranty deed or a special warranty deed? Or is it going to be something else? And then they'll help you out here. Again, if you're using a closing attorney, same thing. Or others specify free of liens, easements, and encumbrances of record or known to seller, but subject to property taxes for the year of closing, covenants, restrictions, and public utility easements of record, existing zoning and government regulations, and list any other matters to which title will be subject. So if there's anything else that the seller is aware of or has been disclosed, we would enter that here, provided there exists at closing no violations of the foregoing. Okay. Title evidence. The party who pays for the owner's title insurance policy will select the closing agent and pay for the title search, including tax and lien search, including municipal lien search if performed, and all other fees charged by closing agent. Seller will deliver to buyer at seller or buyer's expense. All right. So who's paying? Is Lee County. It's typical for seller to pick and pay. Collier County, it's typical for buyer to pick and pay. Okay. Within blank days after the effective date. So this is Lee County. We're going to go here. We'll say within 21 days after the effective date. Well, you know what? Like this one better. At least 7 days before closing. Okay. Check 1. A title insurance commitment by a Florida licensed title insurer setting forth those matters to be discharged by seller at or before closing and upon buyer recording the deed and owner's policy in the amount of the purchase price for fee simple title subject only on the exception stated above. If buyer is paying for owner's title insurance policy and seller has title's owner's policy, seller will deliver a copy to buyer within 15 days. Okay. Or option 2, an abstract of title prepared or brought current by an existing abstract firm or certified as correct by an existing firm. However, if such an abstract is not available to seller, then a prior owner's title policy acceptable to the proposed insurer as a base for reassurance of coverage may be used. The prior policy will include copies of all policy exceptions and an update in a format acceptable to buyer from the policy effective date and certified to buyer or buyer's closing agent, together with copies of all documents recited in the prior policy in the update. If such an abstract or prior policy is not available to seller, then option 1 will be the above for title evidence. Okay. So again, talk to your buyer, talk to your title company, talk to your closing attorney if you're unsure of which would be best for you. But we're going to go ahead and we're going to select option 1, a title insurance commitment by a Florida licensed title insurance or setting forth those matters to be discharged by seller at or before closing and upon buyer recording the deed. Okay. B, title examination. After receipt of the title's evidence, buyer will, within blank days, if left blank, but no later than closing date, deliver written notice to seller of title defects. Title will be deemed acceptable to buyer if buyer fails to deliver proper notice of defects or buyer delivers proper written notice and seller cures the defects within 30 days if left blank. The cure period after receipt of the notice. If defects are cured within the cure period, closing will occur within 10 days after receipt by buyer of notice of such cure. Buyer may elect not to cure defects if seller reasonably believes any defect cannot be cured within the cure period. If the defects are not cured within the cure period, buyer will have 10 days after the receipt of notice of the seller's inability to cure the defects to elect whether to terminate this contract or accept title subject to existing defects and close the transaction without reduction in the purchase price, okay? Because a lot of times vacant land purchases are cash purchases. Yes, if there are defects on title, we can continue to move forward with closing. A lot of times, if there's financing involved, something like this would stop financing until the defect is cured. This is probably not going to be too common with single family home parcels, especially here in our area. But, you know, acquiring large parcels or multiple parcels at a time or a package purchase, you may run into this a little bit more often. But again, any questions with that, reach out to title, reach out to your closing attorney, use your resources at hand. Okay, so option C, survey. Buyer may, at buyer's expense, have the property surveyed and must deliver written notice to seller within 5 days after receiving survey, but not later than 5 days before closing date, of any encroachments on the property, encroachments by the property's improvement on other lands, or deed restrictions or zoning violations. Any such encroachment or violation will be treated in the same manner as a title defect, and seller and buyer's obligations will be determined in accordance to paragraph 8B. Okay, so a lot of times with this, it's a fence or a shed. It might be considered an encroachment on the property, and a survey can determine if any of those exist. Ingress and egress. Seller warrants that the property presently has ingress and egress, okay? Not too common here in Cape, but when you get into some of the more rural areas, you may notice this, maybe in certain parts of the North Cape, or, you know, certain parts of Lehigh, I've seen it, even out into the estates, certain parts of Bonita, a little bit more rural areas, this is more common, but that's why that's there. Any questions about this point on the title section of this contract? Okay. Property condition. Seller will deliver the property to buyer at closing in its present as is condition. Okay, so by default, it's as is, with conditions resulting from buyer's inspection and casualty damage, if any, accepted. Seller will not engage in or permit any activity that would materially alter the property's condition without the buyer's prior written consent. Inspections, check 1 or 2. Okay, so the first one is feasibility study. Buyer will, at buyer's expense and within blank days, by default it's 30, and we're calling that period the feasibility study period, after effective date, and in buyer's sole and absolute discretion, determine whether the property is suitable for buyer's intended use. During the feasibility study period, a buyer may conduct a phase 1 environmental assessment and any other tests, analyses, surveys, and inspections that buyer deems necessary to determine to buyer's satisfaction the property's engineering, architectural, and environmental properties, zoning and zoning restrictions, subdivision statutes, soil and grade, availability of access to public roads, water, and other utilities, consistency with the local, state, and regional growth management plans, availability of permits and government approvals and licenses, and other inspections that buyer deems appropriate. If the property must be rezoned, buyer will obtain the rezoning form, will obtain the rezoning from the appropriate government agencies. Buyer will sign all documents buyer is required to file in connection with the development or rezoning approvals. Buyer gives buyer and its agents, contractors, and assigns the right to enter the property at any time during the feasibility study for the purpose of conducting inspections, provided, however, that buyer, its agents, contractors, and assigns enter the property and conduct inspections at their own risk. Buyer will indemnify and hold seller harmless for losses, damages, costs, claims, and expenses of any nature, including attorney's fees, expenses, and liability incurred in application for rezoning or related proceedings from the liability to any person arising from the conduct of any and all inspections or any work authorized by buyer. Buyer will not engage in any activity that could result in a construction lien being filed against the property without seller's prior written consent. If the transaction does not close, buyer will, at buyer's expense, repair all damages to the property resulting from the inspections and return the property to the condition it was in before conducting the inspections, and release to seller all reports and other work generated as a result of the inspections. All right, you want to inspect the property? Great, go for it. If anybody gets hurt on the property, I'm not an attorney, but this is my understanding of what this says. Anybody gets hurt on the property, you can't sue the seller, for anything that happens. Also, feel free to conduct the inspections, but make sure that when the inspections are over, that you return the property in the same condition that you found it, and that you have not altered the property in any way that will affect its value. Okay. Before expiration of the feasibility study, buyer must deliver written notice to the seller of buyer's determination of whether or not the property is acceptable. Okay, so if it's not acceptable, you must deliver written notice to the seller before the expiration of the feasibility study. Okay, and you also must deliver written notice if you find it acceptable. However, buyer's failure to comply with this notice requirement will constitute acceptance of the property as suitable for buyer's intended use in its as-is condition. If property is unacceptable to buyer and written notice of this fact is timely delivered to the seller, this contract will be deemed terminated and buyer's deposit will be returned. Okay, so you want the money back, deliver written notice that you're terminating the contract. Okay, no written notice constitutes acceptability of the contract, and we're moving forward with this contract. Okay. Or option 2, no feasibility study. Buyer satisfied that the property is suitable for the buyer's purposes, including being satisfied that either public sewage and water are available to the property, or the property will be approved for the installation of a well and or private sewage disposal system, and that existing zoning and other pertinent regulations and restrictions such as subdivision or deed restrictions, concurrency, growth management, environmental contingency are acceptable to the buyer. This contract is not contingent on buyer conducting any further investigations. Right? So they're going to perform a study and do their due diligence, or they're going to not perform the due diligence, and they're going to waive the right to do an inspection. Any question on that? Okay, moving right along. Government regulations, changes in government regulations and levels of service which affects buyer's intended use of the property will not be grounds for terminating this contract if the feasibility study period has expired, or if paragraph 9A2 is selected. Okay. Flood zone. Buyer is advised to verify by survey with the lender and with appropriate government agencies which flood zone the property is in, whether flood insurance is required, and what restrictions apply to improving the property and rebuilding in the event of casualty. Okay, if you need additional protection on this, there is a flood zone addendum that you can add that will add additional coverage and allow extended time to perform your due diligence in that manner. Okay, an insurance agent is another excellent resource to have on your team. An insurance broker is even better, and an insurance broker can basically write with any line of insurance. They're not married to one brand. Okay, coastal construction control line. If any part of the property lies seaward of the CCCL as defined in section 161.053 Florida statutes, seller will provide buyer with an affidavit or survey as required by law delineating the line's location on the property unless buyer waives this requirement in writing. The property being purchased may be subject to coastal erosion and to federal, state, or local regulations that govern coastal property, including delineation of the CCCL rigid coastal protection structures, beach nourishment, and the protection of marine turtles. Additional information can be obtained from the Florida Department of Environmental Protection, including whether there are significant erosion conditions associated with the shoreline of the property purchase. And buyer waives the right to receive a CCCL affidavit or survey. Okay. And there is a coastal construction control line addendum that can be added to the contract again for additional protection on that. Any questions on the coastal construction control line, flood zone, government regulations? Okay. And again, title or closing attorney is going to be an asset to you. Any questions with that, you can always go to them. You can go to an insurance broker as well. Closing procedure and costs. Closing will take place in the county where the property is located and may be conducted by mail or electronic means. If title insurance insures buyer for title defects arising between the title binder effective date and recording of buyer's deed, closing agent will disperse at closing the net sale proceeds to seller and local's cashier's check if seller requests in writing at least 5 days prior before closing, and brokerage fees to broker as per paragraph 21. In addition to other expenses provided in this contract, seller and buyer will pay costs as indicated below. Seller costs, taxes on deed, recording fees for documents needed to cure title, title evidence if applicable in paragraph 8, estoppel fees, other. If you have the seller, you can write the Coldwell Banker 345 broker only fee on here if you so choose. I personally would not. That's already in my listing agreement, so I don't feel that it's necessary to put it on here. Okay, buyer costs, taxes, and recording fees on notes and mortgages, recording fees on the deed and financial statements, loan expenses, title evidence, if applicable under paragraph 8, lender's title policy at the simultaneous issue rate, inspection, survey, insurance, other. Again, you can put the Coldwell Banker brokerage only fee of $345 here if you so choose, but I would have a buyer's disclosure executed prior to entering contract And on that, it discloses the $345 brokerage only fee that the buyers already agreed to pay. All right, prorations, the following items will be made current and prorated as of the day before the closing date. Real estate taxes, including special benefit tax liens imposed by a CDD, interest, bonds, assessments, leases, and other property expenses and revenues. If taxes and assessments for the current year cannot be determined, the previous year's rates will be used with adjustment for any exemptions. Remember that our taxes are paid in arrears here, so this is disclosing the prorations of such. Special assessment by any public body. Okay, we're very familiar with special assessments here in Cape Coral. Regarding special assessments imposed by a public body, seller will pay the full amount of liens that are certified, confirmed, and ratified before closing, and the amount of the last estimate of the assessment if an improvement is substantially completed as of the effective date, but has not resulted in a lien before closing. If buyer will pay all other amounts. If special assessments may be paid in installments, which ours up here in Cape Coral are, okay, seller or buyer will pay installments due after closing. If neither box is selected, by default, buyer will be selected. If seller is checked, seller will pay the assessment in full before or at the time of closing. Public body does not include a homeowners or condominium association. Okay, so if you're in an HOA or a condo, you know, if there's been an assessment placed by said HOA or condo association, this does not cover that. Okay, this is just from public body. Okay, so your utility expansion would be applicable to this. Any questions on special assessments? Okay, property tax disclosure summary. Buyers should not rely on the seller's current property taxes as the amount of property taxes that buyer may be obligated to pay in the year subsequent to purchase. The change of ownership or property improvements triggers reassessments of the property that could result in the higher property taxes. If you have any questions concerning valuation, contact the county property appraiser's office for further information. Foreign Investment and Real Property Tax Act, FIRPTA. We have plenty of properties that this will fall in here. You know, lots of German investors, German influence in our area, some Canadian. So FIRPTA is very much applicable in our area. If seller is a foreign person as defined by FIRPTA, seller and buyer will comply with FIRPTA, which may require seller to provide additional cash at closing. Okay. Sunbelt Title is familiar with FIRPTA, and then a lot of times an attorney or an accountant can be involved when FIRPTA is applicable. Right here in Cape Coral, I have experience working with an excellent company, FIRPTA Solutions. My experience working with them, they were able to get my seller 100% of their escrow back, and they were able to get the property taxes or the amount owed, if you will, basically waived. They're excellent. They're great accountants, and they've got to have a staff of 30 plus people, and they are multilingual there. They speak almost any language you can imagine. But any questions on that, feel free to reach out to me, reach out to your closing attorney or your title company. Okay. Next here, we've got 1031 exchange, right? Working with an investor maybe. If either seller or buyer wish to enter into a like-kind exchange, either simultaneously with closing or after, under Section 1031 of the Internal Revenue Code exchange, the other party will cooperate in all reasonable respects to effectuate the exchange, including executing documents, provided, however, that the cooperating party will incur no liability or costs related to the exchange, and that the closing will not be contingent upon, extended, or delayed by the exchange. Computation of time. Calendar days will be used when computing time periods, except time periods of 5 days or less. Time periods of 5 days or less will be computed without including Saturday, Sunday, or national legal holidays specified in 5 USC 6103A, other than time for acceptance and effective date set forth in paragraph 3. Any time periods provided for or dates specified in this contract, whether pre-printed, handwritten, typewritten, or inserted herein, which shall end or occur on a Saturday, Sunday, or national legal holiday, shall be extended until 5 p.m. of the next business day. And that's where the property is located, so our local time here. Time is of the essence in this contract, okay? So any questions on time, make sure you refer to section 11 of this contract. Any questions on that up until this point? Okay. Risk of loss, eminent domain. If any portion of this property is materially damaged by casualty before closing, or seller negotiates with a governmental authority to transfer all or part of this property in lieu of eminent domain proceedings, or an eminent domain proceeding is initiated, seller will promptly inform buyer. Either party may terminate this contract by written notice to other party within 10 days after the buyer's receipt of seller's notification, and buyer's deposit will be returned, failing which buyer will close in accordance with this contract and receive any payments made by the governmental authority or insurance company, if any. All right, so eminent domain. What I've heard about eminent domain here in our market, bridges, right? So there's talk of another bridge being proposed to join Cape Coral and Fort Myers. Now, if that is accepted and passed, then eminent domain will be placed into effect for wherever that bridge may land on either side of the river. Okay, and if that happens, then written notice must be delivered to all parties, and then either party can opt to cancel the contract if they so choose at that time. Okay, force majeure. Okay, hurricanes. That's where this comes into play. Tropical storms. Seller or buyer will not be required to perform any obligation under this contract or be liable to each other for damages so long as the performance or non-performance of the obligation is delayed, caused, or prevented by an act of God or force majeure. An act of God or force majeure is defined as hurricanes, earthquakes, floods, fire, unusual transportation delays, wars, insurrections, and any other cause not reasonably within the control of seller or buyer, in which by the exercise of due diligence the non-performing party is unable in whole or in part to prevent or overcome. All time periods, including closing date, will be extended for the period that the act of God or force majeure is in place. However, in the event that such act of God or force majeure event continues beyond 30 days, either party may terminate this contract by delivering written notice to the other, and buyer's deposits will be returned. Okay, I had experience with force majeure on a property. Hurricane Irma came through. We were in a state of emergency. Force majeure, we were considered that we were able to call that so long as we were in a state of emergency, or our county was in a state of emergency. Okay, and if that lasts for more than 30 days, then either party may terminate this contract by delivering written notice to the other. Any questions on eminent domain or force majeure? Okay. Notices. All notices will be in writing and delivered to the parties and broker by mail, personal delivery, or electronic means. Buyer's failure to timely deliver written notice to seller when such notice is required by this contract regarding any contingency will render that contingency null and void, and this contract will be construed as if the contingency does not exist. Any notice, document, or item delivered to or received by an attorney or licensee, including a transactions broker representing a party, will be as effective as if delivered to or receiving by that party. Complete agreement. Persons bound. This contract is the entire agreement between seller and buyer. Except for brokerage agreements, no prior or present agreements will bind seller, buyer, or broker unless incorporated into this contract. Modifications of this contract will not be binding unless in writing, signed, or initialed by delivering and delivered by the party to be bound. Electronic signatures will be acceptable and binding. This contract, signatures, initials, documents referenced in this contract, counterparts, and written modifications communicated electronically or on paper will be acceptable for all purposes, including delivery, and will be binding. Handwritten or typewritten terms inserted or attached to this contract prevail over pre-printed terms. If any provision of this contract is or becomes invalid or unenforceable, all remaining provisions will continue to be fully effective. Seller and buyer will use due diligence and good faith in performing all obligations under this contract. This contract will not be recorded in any public record. The terms seller, buyer, and broker may be singular or plural. This contract is binding on the heirs, administrators, executors, personal representatives, and assigns, if permitted, of seller, buyer, and broker. Any questions on that? Okay. Default and dispute resolution. This contract will be construed under Florida law. This paragraph will survive closing or termination of this contract. Seller default. If seller fails, neglects, or refuses to perform seller's obligation under this contract, buyer may elect to receive a return of buyer's deposits without thereby waiving any action for damages resulting from breach and may seek to recover such damages or seek specific performance. Seller will also be liable for the full amount of the brokerage fee. Okay, so if seller defaults, seller's still paying the commission. Buyer default. If buyer fails, neglects, or refuses to perform buyer's obligations under this contract, including payment of deposits within the time specified. Okay, so if you don't deliver the deposit within the 3 days or whatever the contract says, then the buyer's in default. Then the seller may elect to recover and retain the deposits paid and agreed to be paid for the account of seller as agreed upon liquidated damages, consideration for execution of this contract, and full settlement of any claims whereby seller and buyer will be delivered from all further obligations under this contract, or seller at seller's option may proceed in equity to enforce seller's rights under this contract. Okay, so by failure to deliver deposit does not necessarily constitute termination of the contract, and there it is right there specifying that. So if you have a buyer that wants to say that, I would refer them, 1, to an attorney, and 2, to lines 279 through lines 284 of this contract. Okay, any questions on that? Okay, attorney's fees and costs. In any litigation permitted by this contract, the prevailing party shall be entitled to recover from the non-prevailing party costs and fees, including reasonable attorney's fees incurred in conducting the litigation. This paragraph 17 shall survive closing or termination of this contract. Okay, so if an attorney needs to be hired, then whoever is at default is paying for that attorney, and that's basically what that says. Okay, escrow agent, closing agent. Seller and buyer authorize escrow agent and closing agent, collectively agent, to receive, deposit, and hold funds and hold items in escrow and, subject to collection, disperse them upon proper authorization in accordance with Florida law and the terms of this contract, including dispersing brokerage fees, collection or collected means. Any checks tendered or received have become actually and finally collected and deposited in the account of the agent. The parties agree that the agent will not be liable to any person for misdelivery of escrowed items to seller or buyer, unless the misdelivery is due to the agent's willful breach of this contract or gross negligence. If agent interpleads the subject matter of the escrow, agent will pay the filing fees and costs from the deposit and will recover reasonable attorney fees, and costs will be paid from the escrowed funds or equivalent and charged and awarded as court costs in favor of the prevailing party. All right, any questions on how an escrow agent works or closing agent works? That's what this paragraph specifies. Any questions on that? All right. Professional advice, broker liability. Broker advises seller and buyer to verify all facts and representations that are important to them and to consult an appropriate professional for legal advice. For example, interpreting this contract, determining the effect of laws on the property and this transaction, status of title, foreign investor reporting requirements, the effect of property lying partially or totally seaward of the construction control line, etc., and for tax, property condition, environmental, and other specified advice. Broker acknowledges that broker does not reside in the property and that all representations, oral, written, or otherwise, by broker are based on seller representations or public records. Buyer agrees to rely solely on seller, professional inspectors, and government agencies for verification of the property condition and facts that materially affect the property value. Seller and buyer respectively will pay all costs, expenses, including reasonable attorney fees and all levels, incurred by buyer and brokers, officers, directors, agents, and employees in connection with or arising from sellers or buyers' misstatement or failure to perform contractual obligations. Seller and buyer hold harmless and release broker and brokers, officers, directors, agents, and employees from all liability for loss or damage based on seller or buyer's misstatements or failure to perform contractual obligations. The use or display of listing data by third parties, including but not limited to photographs, images, graphics, video recordings, virtual tours, drawings, written descriptions, and remarks related to the property, broker's performance. At seller or buyer's request of any task beyond the scope of services regulated by Chapter 475 Florida statutes as amended, including buyer's referral, recommendation, or retention of any such vendor, buyer's products, or services provided by any vendor, and expenses incurred by any vendor. Seller and buyer each assume full responsibility for selecting and compensating their respective vendors. This paragraph will not relieve broker of statutory obligations. For purposes of this paragraph, broker will be treated as a party to this contract. This paragraph will survive closing. Commercial, any questions on that? Okay. Commercial Real Estate Sales Commission Lien Act. If the property is commercial real estate as defined by Section 475.701 Florida statutes, the following disclosure will apply. The Florida Commercial Real Estate Sales Commission Lien Act provides that when a broker has earned a commission by performing licensed services under a brokerage agreement with you, the broker may claim a lien against your net sales proceeds for the broker's commission. A broker's lien rights under the Act cannot be waived before the commission is earned. Okay, and if you have any questions about commercial real estate, please reach out to me. I'll be happy to put you in touch with our commercial real estate advisor for our area. We also have a RCC program, which is kind of a bridge, if you will, from residential to commercial. It's a 2-day class. It'll get you the RCC designation. And what that designation does is it'll get you legal protection in the commercial world. Yes, we are a residential brokerage, but we're not going to prohibit you from selling commercial real estate. In fact, we'd love you to sell commercial real estate. But we just want to make sure that you know what you're doing. So we ask that you obtain that RCC designation in order for your legal assistance to cover you in that field. Any questions about that, feel free to reach out to me at any time. All right, 21, we're getting close to the end here. Brokers, the licensees and brokerages named below are collectively referred to as broker. Instruction to closing agent, seller, and buyer, direct closing agent to disperse at closing the full amount of the brokerage fees as specified in separate brokerage agreements with all parties and cooperative agreements between the brokers, except to the extent broker has retained such fees from the escrowed funds. This paragraph will not be used to modify any MLS or other offer of compensation made by seller or listing broker to cooperating fees. Any questions on that? Okay. Seller, sales associates, name and license number. Okay. So this is going to be Kurt Meltzer. Click on his name. There's his license number right there, agent ID. Okay. Okay. Moving right along. Seller sales. Go. go. Copy their email address, listing email address. Okay, their phone number. This just makes it convenient for title. You know, when you turn in the contract, all the information is right there for title. Brokerage. Okay. There you go. Okay, the following items are included in the attached addenda and will be incorporated in this contract. Okay, so if you have additional addenda, you can put it here, and then a coastal construction control line. Maybe you have appraisal, contingency, et cetera, and if there's any additional terms, you can specify them here. Okay, and then if you are on the listing side, okay, and you're in a multiple offer situation, you only want to negotiate one contract at a time, okay? And in order to definitely know that a contract is dead, select this and select this and return it to the buyer's agent to let them know that the seller has rejected the buyer's offer. And I might even have the seller initial right there. That way you've got it in writing that offer is dead and out of play, and you don't run the risk of being accused of trying to negotiate multiple offers at the same time. Okay. This is intended to be a legally binding contract. If not fully understood, seek the advice of an attorney before signing. Okay, I would always reread that line before handing my customer the pen, or before submitting them the email with the signature request for digital signature. Okay, and then make sure that your buyer initial this page too. Sometimes this gets overlooked. And if you do know the seller's address, please enter it here. Again, this make it easier and convenient for title. And then once all parties have executed and there is a clear effective date, please do put it on this contract. And when you do that and it's returned back to all parties, there's no question of it, and it's right here in black and white on the contract. So everybody is well aware of what the actual effective date is, okay? And right here it says the date on which the last party signed or initialed and delivered the final offer or counter offer. Okay, and don't forget that this page needs initialed too. A lot of times that's overlooked. Okay. Well, that's all I got for everybody. Is there any questions at all? I want to open up the floor. Please let me know if you have any questions. All right. If not, I have recorded this video. As soon as it uploads, I'll be sure to send a copy out to everybody. But thank you for your time this morning, and I appreciate you joining me. Guys, have a good day.